Good day, everyone. My name is Ugochi Agala. I'm a lawyer with an LLM from the University of Hertfordshire, United Kingdom, and a senior research assistant with the Rivers State Judiciary. Ladies and gentlemen, please allow me to introduce the keynote speakers, the keynote presenters, all other presenters, my Lord Justices of the Supreme Court, Justices of the Courts of Appeal, and all other judges, senior advocates, professors, senior lawyers, colleagues, ladies and gentlemen. I welcome you to the second edition of the Courts and Society webinar series with the theme, The Courts as Agents of Social Change. Please allow me to introduce the founder, CEO of A.T.Socio-Judicial Consulting, Your Honor, a former magistrate of Lagos State, Nigeria, A.T.Socio Ayemo. She retired from the magistracy of Lagos State, Nigeria, after 12 years in 3 of the busiest magisterial districts in the state. She graduated from Benue State University, Makurdi, Nigeria, and obtained a master's in law degree from the University of Lagos, Nigeria. Your Honor also earned a master's degree in judicial studies and a PhD in judicial studies from University of Nevada, Reno, a Carnegie Tier 1 research university in the United States. The Journal of Blacks in Higher Education recognized her as the first Black woman to earn a PhD in judicial studies in the United States. She's been researching on courts and society for over a decade now. I now hand over to the convener of this Courts and Society webinar, the first of its kind, A.T.Socio Ayemo. Thank you.
Thank you, Ugochi. Thank you so much. My lords, thank you for attending, for coming. I want to first of all acknowledge and thank Justice Alusin Sosay of the Supreme Court of Sierra Leone. I want to appreciate all the justices of the Supreme Court in attendance and those NJI team. I don't know specifically who is around and who is not, but I know that there are justices of the Supreme Court, justices of the Court of Appeal, judges of the High Court, professors, intellectuals, and administrator of the National Judicial Institute, directors of various respects. I thank you all, students, other presenters here, Judge Dimitrovic, Professor Itome, Dr. Makoba, as well as some Amadi that will be joining us shortly. Thank you all so much for being part of this event. I appreciate you so much. Everybody, to the second edition. The first edition was on the impact of judicial precedents on the development of law and society, and it held in April 25th of this year. And basically a brief history of Courts and Society webinar. A detailed history is already in the first edition, which is available on YouTube. Now, this is a research that has on and off, formally and informally, inadvertently, in over 19 years of research. And believe it or not, it started from an inquisitive and passionate mind of an 8-year-old girl, far away in northern Nigeria, Maiduguri, where her father was a professor of law. And I had an encounter with a middle-aged woman who was about to be stoned to death for adultery. At that time, my mind started to wander on what the law and the courts was about women and about society. And of course, my father, who was then the professor, the dean of law of the University of Maiduguri, and eventually the acting vice chancellor of the university, was very helpful in guiding my paths. Eventually, I decided to, even though I had a choice of going to work in LNG in Port Harcourt, I decided to go to an NGO to do a pro bono work on human rights, which was SERAC, Social and Economic Rights Action Center, where I got experience with society. And that for me was an eye-opener, because some of the society members I was dealing with in Morocco, Makoko, and the Niger Delta region, where Lokopiri and some of the places we visited on the Niger Delta oil spillage issue, were very scared of the courts, and not in a good way. And so that began to make me, think about joining the village to make change. eventually. And that took me to the magistracy of Lagos State, where I served for 12 years and retired May 2019. Of course, I was very inquisitive. That inquisitive mindset of an 8-year-old grew up, and I went on to study and found out that what courts face in Nigeria, in Africa, in Asia, is the same thing with even other developed countries like the United States. I sat and I met judges from all walks of life, from all departments and all jurisdictions of courts, family, criminal, Supreme Court, judges of various states, judges from Canada and other states. And I found out that it was the same thing. Judges face the same struggle, we face the same challenges, and we have the same role. And of course, after graduation, I opened the company A.T.Socio-Judicial Consulting, which we'll talk about as we go. And that company, which is focused on research and redefining or defining the role of court in society to connect society back to court, or to principally build the public confidence in our court systems. So the first symposium was in honor of my late father, who is, for me, the face of courts as agents of social change, who, through a judgment of his, created a jurisprudence for social change for women in Nigeria and eventually Africa. And so that Honorable Justice Nikki Toby Biennial Symposium gave birth to the Courts and Society webinar series, where each of the sessions that we had in the webinar, we're going to the next stage and taking it piecemeal and breaking it down. Like we're taking the bone and taking, chewing the bone, and from this we would go to another level where we would indeed hope that there will be social change impacts. So today we'll be celebrating the judicial jurisprudence of Sierra Leone, Nigeria, and the United States. And Nigeria and the United States would always be part of all of the webinars, but we will be changing countries as we go. And that is because of the impact of Nigeria, where it all started. The Nigerian judiciary, a major inspiration to this, and the American judiciary, or American judicial system, or National Judicial College, gave me that platform to express and to compare and to come to a place of knowledge and understanding of how judicial systems across the world are one and the same thing. So we'll be celebrating Sierra Leone judicial jurisprudence, and with us, I would go take everybody's profile together to save time for us. So to celebrate Sierra Leone's judicial jurisprudence, we have Honorable Justice Alison Sase. He's a justice of the Supreme Court of Sierra Leone and a judge of the United Nations, I beg your pardon, Residual Special Court for Sierra Leone in The Hague, Netherlands. He has served on the bench for about 15 years. He has previously served also as a High Court judge before his elevation to the Court of Appeal and now the Supreme Court. Apart from his vast experience on the bench, Justice Sase is also a legal scholar who lectures criminal law at the Sierra Leone Law School. He's also a member of the Council of Legal Education, a body responsible for legal education in Sierra Leone. Justice Sase is a recipient of the highest national award, the Grand Officer of the Order of the Rockall, and award bestowed on him for his contribution to legal education in Sierra Leone by His Excellency, the President of the Republic of Sierra Leone. Justice Sase will be giving our keynote speech today. And to acknowledge socioeconomic impacts on Africa's judicial jurisprudence, because we're talking about social change, and it's important that we go to the society and understand members of the society, statesmen and nationalists, people who have contributed to not just development in their field and in their respectful careers or professions, but also to national and democratic development. Distinguished Professor Patrick Okedinachi Utome. And Professor Utome is a Nigerian professor of political economy and a management expert devoted to building a better society. He is the founder of the Center for Value in Leadership. He is the founding professor at the Lagos State Business School at African University. Professor Utome is a former presidential candidate who has served in senior positions in Nigeria's public and private sectors. He was an advisor to the President of Nigeria, provided consultancy services on some public policy papers, I beg your pardon, and founded the African Democratic Congress. He also is a founder and he has also founded and co-founded several civil society groups on good governance and accountability. He has also served in the Lagos Chambers of Commerce and Industries and various other public sectors. Professor Tome is the author of several management and policy books. He has published in diverse areas on leadership, nationalism, good governance, social economy, socio-political development, and stability. He has also studied and written about the political economy of growth in Latin America and Asia, particularly Brazil, Indonesia, Malaysia, Singapore, India, and Hong Kong. Professor Tome is a fellow of the Institute of Management Consultants of Nigeria. He is a regular speaker on various national and international platforms. He was a scholar in residence at the American University, Washington, D.C., a research associate, and also a research associate at Harvard Business School. And next is Dr. Makoba. Dr. Johnson Makoba is a professor of sociology at the University of Nevada, Reno. He's editor-in-chief of the International Journal of Technology and Management. Dr. Makoba is the author of 2 books on development in sub-Saharan Africa and has published several book chapters and articles in several international scholarly journals. Dr. Makoba established Ugandan Foundations for Credit and Community Assistance. This microfinance institution provides financial assistance and support services to qualified Ugandan and Tanzanian students from low-income families, enabling them to attend university or vocational schools in their home countries. Dr. Makoba also established a policy-oriented think tank called the Ugandan Research Institute. His area of specialization include African and third world developments, organizations and bureaucracies, race and ethnic relations in the United States of America and globally, and African states NGO relations. His current research is on the role of agriculture in the economic development of sub-Saharan African countries and other issues in third world development studies. Dr. Makoba is a recipient of the 2016 and 2019 Carnegie African Diaspora Fellowship. To celebrate America's judicial jurisprudence, we have Honorable Dr. Stephanie Domitrovich, who is a senior judge who serves as General Jurisdiction Senior Trial Judge in Erie, Pennsylvania, in the United States. She served for over 32 years as a trial judge. Judge Domitrovich is involved in training judges and is passionate about developing judicial systems. Under the U.S. Agency for International Development, she educated judges in Kazakhstan and, okay, now this is the tough part, Kyrgyzstan's former Soviet Republic nations in developing their judicial systems. She is the program chair for the National Conference of State Trial Judges. She serves in planning education programs for the Technology Committee of the Judicial Division of the American Bar Association. Judge Domitrovich, I would introduce you to the NJI. I'm sure that would need your expertise in certain areas. Judge Domitrovich is a fellow of the American Academy of Forensic Sciences and a former chair of its jurisprudence section. She currently serves as a member of the Organization of Scientific Area Committees and as a board member of the Forensic Specialties Accreditation Board. She is also a special editor for the Judges Journal. Judge Domitrovich has presented numerous domestic and international papers on law and society, including her PhD dissertation for law and society at Humboldt University of Berlin, Germany in 2007. In May 2006, Judge Domitrovich, my mentor, made history as the first graduate to earn a PhD in judicial studies from the University of Nevada, Reno, which makes her the first person to earn a PhD in judicial studies globally. And that is because the University of Nevada, Reno is the only institution at the moment that offers a PhD in judicial studies. Thank you, and that would be all for now. I would give the floor to Judge Alison Sosay of the Sierra Leone Supreme Court. Thank you, sir, my lord.
Thank you very much for your brief introduction. Sorry, come quick, come. Yes, for your brief introduction. And let me welcome you all to the second edition of the Courts and Webinar Society series in 2022. Are you hearing me?
Yes, sir.
Yes. May I acknowledge the presence of my lords, Supreme Court justices in Nigeria, and also the other judges of the Superior Court of Judicature. And also, may I also acknowledge the presence of the National Judicial Institute of Nigeria and all participants. Our topic for this edition is the court as agents of social change. According to John A. McInnes, professor of sociology and practice, Paul distinguished scholar, social change refers to an alteration in the social order of the society. End of quote. A dynamic view holds that he referred to social change as an alteration in the social order of society. The dynamic court view holds that courts are successful agents in producing social change. Professor Rosenberg, in his analysis on whether courts are powerful agents in having social change, highlighted two main court views. In other words, there are two main court views on this topic for discussion: the dynamic court view and the constrained court view. The dynamic court view holds the view that courts are successful agents producing social change, while the constrained court view is the opposite. The American rights movement was an important demonstration in Rosenberg's argument of the constrained court view. The constrained court view maintains that courts cannot produce social change. There are two schools of thought on this topic. We'll hear the position of the other participants later on this issue. Sierra Leone, my country, as a case study, there are several instances where the courts have demonstrated bold steps in influencing positive social change. In Joseph Aka, it was a case in the Supreme Court against the Attorney General. The Supreme Court judges ruled that the state indiscriminatory amendment of the 1961 Constitution. In other words, you have to be, if you are of Afro-Negro descent, you cannot be a citizen of our country. And that was what was enshrined in the independence, post-independence Constitution of Sierra Leone, the 1961 Constitution. It is worthy to note that the Privy Council, in the pre-colonial era, because my lords know the hierarchy of the courts then, we had the Privy Council, which was like an appellate court. It was an appellate court to the courts in the various territories, the colonial territories. Of course, the Privy Council then upheld the decision. This ruling, up to recent times, has significantly influenced statutory changes in respect of citizenship rights in my country. As we have today a Citizenship Amendment Act of 2006 that amends the discriminatory provision of the 2006 and 1961 Citizenship Act. And that amendment has since been enforced in 1973. Also, the response of our judiciary in sexual offenses and related offenses. In recent times, and some of the favorable outcomes it has produced, an indication of the court's powerful tendency to inspire positive social change in my country. For instance, the constant abuse of guards with impunity had been the state of affairs in our country. Girls below the ages of 18 and even below the age of 13. There has been several convictions in that regard. We now have a specialized court dealing with that kind of situation. We have the sexual offenses model court. With these convictions, gone are the days that young girls are being abused with impunity in our country. It has served as a deterrent. The manner in which these cases are decided in my country has created much more awareness. Very recently, the judiciary of Sierra Leone declared a judicial activism. Judicial activism was established all over the country, both the capital city, Freetown, and the provinces and its environs. Because during that period of judicial activism, I personally had the opportunity of going to the correctional centers all over this country, in our country, Sierra Leone, and I discharged over 300 inmates at the correctional centers. You had those who were there, they had already served their sentences because due to administrative problems, they were still there. Because you had those who were there for petty crimes, and for those ones, they were not on bail. It was a very unfortunate situation, but I had to take part in that exercise, and it was quite very much successful. It had an impact. That was part of social change. And how was that? A lot of these inmates have been incorporated, they've been absorbed in society, and they are very much now part of the development process. Furthermore, another example of how the judiciary can act as a tool for social change is seen in other parts of Africa. Let me move now away from my country to other parts of Africa. As seen in the bold decision handed down by the Supreme Court of Kenya in overturning the 2017 presidential elections of Kenya. Because quite recently, however, the Constitutional Court of Malawi also delivered a similar ruling and nullified the election of the incumbent President Peter Mutharika in May and ordered fresh elections to be conducted. The courts there were acting as an agent for social change. Of course, we all can take judicial notice of the fact of what happens in elections, both pre and post elections. And the court there has a role to play, and that role is to enable stability to prevail, and that again is part of social change. These decisions have sparked overwhelming commendations within and outside Africa and have set the stage for decent electioneering. The arrest and detention of former President of South Africa, Jacob Zuma, by the South African Court for Contempt of the court. It also serves as an example of the role of the justice system or the courts in other parts of Africa. Like you said, my lady, that we all have common problems, but they differ to some extent. What prevails in Nigeria might not quite differ from what prevails in Sierra Leone. But every state or nation has its own unique features and incidents which require the intervention of the justice system or the court. These cases speak volumes of the courts serving as agents for social change. I shall conclude my keynote speech in view of time by inviting the views of the other participants on this important jurisprudential topic. I reiterate that this is an interactive session. It requires all ideas to be on board, and we require our various experiences in our various countries to be demonstrated at this webinar, at this second edition of the webinar. I thank the organizers of the 2022 webinar for the opportunity accorded to me as keynote speaker, and I thank you all.
We cannot hear you.
I beg your
Hello?
pardon. Thank you so much, my lord. That was a wonderful presentation and of a revelation about judicial activism in Sierra Leone. I really enjoyed that part. So without wasting time, we'll go to our next presenter, the first discussant, Professor Pat Utomi. Professor. Hello? Professor Utomi, please.
They normally see me screen, but they hear me voice later.
Professor Utomi. Dr. Makoba, you can go on, please, so that would.
Oh, okay. You can hear me, I hope.
Yes, we can.
Okay, and I also want to make the correction that I'm actually speaking from home. You will probably see Karen Makoba. That's my wife's Zoom connection. Thank you very much, organizer and moderator of this webinar, second webinar session, Dr. Toby. I also would like to thank the keynote speaker and the Supreme Court Justice of Sierra Leone and other distinguished panelists. What I'm going to do is really to share with you some observations about courts as agents of social change in Africa, with the hope that this can motivate or stimulate more research, because the quick review that I did shows there's a lot of very interesting stuff going on mentioned by the Supreme Court Justice, for instance, but really not in a coherent scholarship or in terms of publications. So I hope this webinar and the conversations that we are going to have here will motivate scholars, professionals, legal scholars in particular, social scientists, to do more work. As you probably are aware, social change or progress is normally brought about through policy formulation and effective implementation of those policies. This is this is normally the jurisdiction of the legislature, parliament, and the government or the executive. But as you will see that the three branches of government, the legislature, the government, and the judiciary certainly have to play an important role. And that's where I hope we can, that interface would be very critical, especially in terms of sustainable social change. On the other hand, courts act as legal advisors when it comes to having an interpretation of the Constitution, thereby playing a role in policy making. This means that when it comes to being agents of change, courts play an important role in this manner. Furthermore, when it comes to setting precedents for legal cases on issues that are sensitive to society, usually it is the courts that people look up to. And in fact, in the case of the United States, for instance, it's normally the jurisprudence of the courts of appeal or the high court to set a precedent that will have an eventual impact on the community, such as the famous Brown v. Board of Education relating to racial segregation in schools, or Roe v. Wade pertaining to abortion, which, as you all know, was recently reversed by the US Supreme Court. As the reversal of Roe v. Wade indicates, the US Supreme Court is not the fundamental agent of social change. In fact, some scholars have argued that. Rather, this role lies with citizens participating in populist movements such as pro-choice or civil rights movements. The US Supreme Court decisions are not self-implementing. Indeed, without the support of government or citizens, court decisions ordering or mandating social change are unlikely to bring about the desired change in people's lives in meaningful ways. And that is very instructive in terms of the fact that, yes, you can have rulings that would bring about change, but in terms of sustainable change, you may need more than that. In the case of Uganda, where I'm originally from, the 1995 Constitution seeks to promote and safeguard extensive rights of citizens as they pertain to human rights, social justice, and equitable economic development. And yet, in reality, according to the most recent report issued by the Uganda Law Society, it actually documents the violation of both the Uganda Constitution and the rule of law in the country. And the report observes that sustainable social, political, and economic progress can only exist in societies or countries where the rule of law exists or is respected. The Uganda Law Society report points to human rights abuses that include infringements to media freedoms, arbitrary arrest, detention without trial, and disappearances of citizens and members of opposition parties during and after, especially the 2021 general elections. In sub-Saharan Africa, South Africa seems to be the exception. And as I was reviewing some of this, I found it very interesting or fascinating. An important element in South Africa's historic transition after the end of apartheid in 1992 was the adoption of one of the most progressive constitutions in the world. The interim constitution adopted in 1993, followed by the final constitution in 1997, provided a platform to extend a range of human and social economic rights to vulnerable and disadvantaged South Africans. The Constitution also provided a wide range of mechanisms and machinery for effective public interest litigation. These included extensive fundamental rights, such as socioeconomic rights, as well as general standing provisions and wide remedial powers. According to a report by the Atlantic Foundation. This is an international nonprofit organization that operated in South Africa from 1994 to 2013, when it actually closed, investing over $55 million in grants to advance social justice in the post-apartheid South Africa. Its overall goal was to support what they called strategic public interest litigation, certainly working with various human rights non-governmental organizations and funding them. According to the Atlantic Foundation's 28 report, the impact of its grant support has led to many positive socioeconomic constitutional court rulings since 1996. Examples of these include the Richvest ruling, where a community was awarded ownership of the mineral rights on land from which they had been forcibly removed under apartheid. Also, a ruling instructing the government to roll out antiretroviral drugs to people with HIV and AIDS. The other one is the striking down of the Communal Land Rights Act 2 of 2004, which prevented women in communal areas from owning or inheriting land. Also, in a celebrated Nigerian case, Mojeku v. Mojoku, where the late Honorable Justice Nick Toby ruled that women had the right to inheritance. These and other rulings have been groundbreaking and transformative, thereby improving the lives of millions of people in South Africa, in spite of these, and in the case of Nigeria as well, in spite of these achievements, South Africa continues to face massive inequality and poverty, which means it's something that is ongoing. And as you probably noted in the case of even the US, reversal of those cases like Roe v. Wade. It's clear that court decisions can contribute to change. There's no doubt about that. However, tangible and lasting social change requires the collective support of the government, legislature, courts, and ultimately the citizens and their grassroots organizations. Thank you very much. Thanks for listening.
Thank you, Dr. Makoba. So Tommy should be around. Sorry about that.
Yes, I am around.
Yes, sir. Thank you.
Thank you very much. First, let me say that it is a privilege and a pleasure to be able to join. Let me, as we like to say in Nigeria, stand on all the existing protocols. I particularly feel honored by this invitation because I have through the years persisted in challenging my friends who are barristers with a very important role they have in how society makes progress. I say this particularly because when we talk about change, I mean, change is the most constant thing in life. It will always happen. But the kind of changes that we talk about in these conversations is transformational kind of change that changes the trajectory of society. I mean, a clear and great example of this kind of change was the patience, the long, tenacity of one gentleman in the British Parliament on the abolition of slavery. We all know the famous story of William Wilberforce and how eventually his pressures led to earth-shaking change in how human beings, their dignity is considered. But I particularly come to this conversation not as a lawyer, I'm not, but as one whose background is essentially in political science and economics, but who, in tracking the history of human progress, likes to say that true human progress is a function of, yes, of a variety of things, but almost very importantly, the role of institutions. Fortunately, a lot of historians in recent times have come to recognize the primacy of the place of institutions in the advance of human progress. British historian Neil Ferguson, in one of the more remarkable of works of an epic nature in his book, Civilization, the West versus the Rest, or in another edition, the 6 killer apps of Western progress, points to how important institutions are to progress. And really, truly, institutions are evolutionary in their nature. One of the best conversations around institutions was offered by a Nobel Prize-winning economic historian, Douglas North, in his 1990 book, Institutions, Institutional Change, and Economic Performance. So really, truly, most economic progress is a function of how institutions are built that set the boundaries to conduct, which then ultimately reduce uncertainty and lead to classical economic performance. I can argue that there are those whose work show us that the judiciary plays a most important role from the sets of decisions that it makes in setting the course and the tone of economic progress. Indeed, and in fact, two University of Chicago Graduate School of Business professors, Raghuram Rajan and Luigi Zingales, in their remarkable book, Saving Capitalism from the Capitalists, argue that capitalist advance, in fact, the most threat to capitalist advance is actually today's successful capitalists, because economic progress is a function of what the Austrian American economist Joseph Schumpeter likes to call creative destruction. I mean, today's dominant value through what we now refer to as disruption is creatively destroyed by a new idea, usually from somebody who doesn't have the kind of resources or clout as today's dominant producer of that which is value. So invariably, those powerful people try to put down those who could be tomorrow's great value creators. However, in some societies, it's easier to get access to, say, capital and be able to unseat today's dominant capitalists. Rajan and Zingales, in that book, in fact, go as far as to argue and name a US Supreme Court Justice, Louis Brandeis, who they give plenty of credit for why America is one of the easiest places for entrepreneurs to emerge in today's world. And so their work and several other works show that really and truly, institutions that allow for progress can evolve when the judiciary, well-informed, makes certain kinds of decisions. And I emphasize well-informed because I understand, I sympathize with judges. Many of the things that change the course of human history come from areas that ordinarily, typically are so technical that it will take a person who has exposed themselves a great deal to be able to see the nuances that ultimately advance the cause that the rule of law and all of those sit for. And this is why I have persistently through the years challenged my friends in the Nigerian Bar Association to play a more activist role in social issues. The public interest section of the Nigerian bar, of course, has repeatedly, continually invited me to their programs. I think the last time I spoke at one of those a few months ago, I actually said to them, I wonder why you keep inviting me back after I knock you guys so hard every time I come here. But obviously there must be some appreciation of the points that I'm trying to make. I mean, a couple of years ago, I carried on so much about it, speaking to the Lagos, one of the sections of the Lagos bar, that a group of lawyers agreed to found an NGO called LIFE, L-I-F-F-E, Lawyers Interested in Free and Fair Elections. Because in many ways, I think that not only lawyers, judges in the work that they do are guardians, some kind of Praetorian guards of the social order, which needs to constantly adapt and change. And as they adapt and they change, society will experience more progress, more justice, more fairness. And so they have a really fundamental role to play in this regard. If I go back to Douglas North and his work on how institutions emerge, one of the clear things that he does contribute is that institutions come from the activities of interested parties, each trying to get their way, their preferred view of things, take advantage of others. Again, one of the things from law that I like to throw at people a great deal comes from a nice small book written about 1850, that's titled The Law, by the French laissez-faire pamphleteer, if I would call him that, who essentially argues that man in nature likes to pursue gain without pain. And if man likes to pursue gain without pain, he uses the law when he's more powerful to enshrine or encode his way. And so it is in activism, both in the judiciary itself and the various interests playing, that leads to everybody eventually agreeing to something that we can call a level playing field that has boundaries that essentially give people a sense of certainty that the right thing will be done and social progress can be anticipated to flow in the appropriate direction. And so I would like to attribute to the work that many lawyers have done, say that one of the reasons I was a huge fan of the late Chief Gani Fawemi was that he litigated everything he could. Because in litigating matters, the opportunity is created for judges acting in the interest of the common good to begin to build boundaries. And those boundaries invariably reduce the kind of risk involved in economic intercourse, and those lead to the kinds of investments that lead to social progress. I was not told how long to speak for, so I'm going to kind of begin to put a little break on before I overtalk. I can speak forever on these matters, and I don't want to be an unwelcome guest. Essentially to say, in summing up, that the role of lawyers and the role of the judiciary in ensuring that social change does take place is a very critical one. And the movement is not a straight graph, as been pointed out here, just in recent examples in the US with the Supreme Court decision on Roe v. Wade. Society begins again to grind until there is a consensus. I think interestingly, and I'll close with this, I had an experience as a graduate student in the US of being selected to serve an internship on the Hill, working with members of the Indiana delegation to the US Congress. It happened to be the season during which Sandra Day O'Connor sat for the first time, the first woman in the US Supreme Court. Just the day, I think, after Anwar Sadat was assassinated, because I had the privilege of being available at both events during that period. But what came to me sitting there in the gallery of the US Supreme Court as Sandra Day O'Connor sat for the first time as a woman justice, is that the kind of progress that we take for granted could not take place without civil society. It was the pressures of civil society that created the conditions that eventually led to that woman sitting on that chair. And her role in that chair helped expand the way that the judiciary affected change in America. And I think that we must never give up on the possibilities of the human spirit as the courts continue to weigh in on fundamental social issues. I believe that the courts are important for change. Yes, a radically activist court may have its challenges, but a court focus on justice can lead to significant social change. I thank you for listening to me.
Thank you so much, sir. Thank you so much, Prof. As some of you can see, Prof is in transit. Thank you so much for the discomfort you went through, sir, to be part of this webinar. We really, really appreciate you.
It's a pleasure.
Safe travels, sir. Thank you so much.
All right,
so much. So for the next speaker would be Judge Demetrovich, please.
To our esteemed speakers, especially to the Honorable Just A.T.Socio-Judicial, Justice of the Supreme Court of Sierra Leone, to all of the esteemed professors, the attendees, the viewers, and especially our organizer and coordinator, the Honorable Dr. A.T.Socio-Toby Ayemo, and founder and CEO and convener. Thank you for inviting me to join this outstanding international panel of experts and judges. I begin my remarks noting that many vital legal concepts were developed by the ancient Greeks to create a world of civilization. And I am proud to be the daughter of a Greek immigrant who became a United States citizen. So my roots are also with the Greeks. The ancient Greeks knew the core of political and legal theory was adhering to precedents. That is the importance of avoiding arbitrariness when deciding legal cases in the courts. This core principle, known as precedents, can be traced to the ancient Greek philosophers. Aristotle believed, as we believe, that like cases should be treated alike. Aristotle is considered as the most influential classical Greek thinker as to the subject of justice. He defined justice as proportionate equality, in that like cases be treated alike or equally in direct proportion to their alikeness or equality. The courts today should stand on the shoulders of Aristotle. This concept of justice requires judges to track intrinsic similarities in the relevant facts between cases. If case A is objectively like case B in its relevant facts, then under the doctrine of precedence, these two cases should be decided in a similar way. The concept of precedence ensures judicial decisions are consistent with the rule of law. Precedence is our cornerstone vehicle that merges law and justice as one. Indeed, precedence is where law meets justice. Therefore, failure to respect and abide by precedents in the law without distinguishing or overruling the precedent will make the people we serve perceive justice in the law does not exist. If the people do not perceive justice, regardless of how we think the law is just, then we have no justice. The perception of justice is in the eyes of the beholders, the people we serve as judges. Abandoning precedents without a reason to distinguish the court cases before us can threaten and undermine both the perception of the people as well as the reality of justice in our legal systems. We as judges must demonstrate we are committed to justice by analyzing each case for its precedential value. In deciding whether to overrule precedent, courts must assess whether changing social attitudes or other factual circumstances exist that have eroded a precedential case's foundation. An example in the United States is the famous United States Supreme Court decision of Brown versus Board of Education. The precedential case at that time was Plessy versus Ferguson, wherein the court had ruled racial segregation laws did not violate the United States Constitution as long as the facilities for each race were equal in quality, a doctrine that came to be known as separate but equal. The Plessy versus Ferguson decision legitimized the many state laws reestablishing racial segregation that had been passed in the American South after the end of the Reconstruction era, which were the years of 1865 to 1877. In May 1954, the Supreme Court issued a unanimous 9-0 decision in favor of the Browns in the Board of Education case. The court ruled separate educational facilities are inherently unequal, and therefore laws that impose them violate the Equal Protection Clause of the 14th Amendment of the United States Constitution. Court ruled United States state laws establishing racial segregation in public schools are unconstitutional, even if the segregated schools are otherwise equal in quality. The court's decision partially overruled its 1986 decision, Plessy versus Ferguson, declaring the separate but equal notion was unconstitutional for American public schools and educational facilities. Brown versus Board of Education became a landmark presidential decision, paving the way for integration and a major victory of the civil rights movement, as well as a model for many future impact litigation cases. Brown versus Board of Education reflected the changing social attitudes and its apparent relevant facts and social norms evolved into new legal principles, establishing new legal principle in favor of social justice. As a whole, precedents establish stability and consistency, thereby requiring judges to know the law and continue their judicial education to keep up with the law in cases before these judges. When I campaigned as an elected judge, my mantra was, a judge is the teacher of the law as well as a student of the law. Dr. Judge Ari Toby Ayama and I are part of a small group of judges who have earned our PhDs through research and original analytical reasoning. We wrote dissertations that had to be defended before select faculty members at the University of Nevada at Reno after attending and participate in numerous judicial education courses and examinations. Judicial education is priceless. As I myself learned as a judicial instructor when the Agency for International Development hired me to travel and teach in the countries of the former Soviet Union, Kazakhstan, and Kyrgyzstan. The judges of these countries thirsted for judicial education for 7 years and were eager for judicial education. These judges explained to me and the 2 other judges teaching them that judicial education was vital to their roles as judges. It is interesting that only when a right is taken away is when we realize the value of that right. These judges realized the value of education to their work as judges. Education ensures an independent judiciary free of any other intervening officials. Judicial education ensures the independence of the judiciary. Judicial education is therefore priceless. and we must encourage that other judges across the globe have the opportunities to continue to receive their judicial education. The ancient Greeks and Greek mythology looked to Athena, who was associated with wisdom and peacefulness. Since the Renaissance, Athena has become an international symbol of wisdom, the arts, and classical learning. Athena is a symbol of freedom and democracy, which the Parthenon on the Acropolis at Athens is dedicated to her. She was regarded as the patron of cities, as she represented the concept of civilization in literature, as with the stories of the Odyssey and Oresteia. Athena, as written in literature, created the Furies, who are represented today by prosecutors, and the Fates, who are represented today as the jurors on jury panels who decide the fates of others. The Oresteia is a trilogy of Greek tragedies written by Aeschylus in the 5th century BC concerning the murder of Agamemnon by Clytemnestra and the murder of Clytemnestra by Orestes, her own son, which is the trial of Orestes. The Furies hunted down Orestes, and when they found him, Orestes pleads to the goddess Athena for help and deliverance. Athena then granted him his request in the form of a trial. It is important that Athena did not just forgive Orestes and forbid the Furies from chasing him. She intended to put him to a trial and find a just answer to the question regarding his innocence. This is the first example of proper litigation in the trilogy and illuminates the change from emotional retaliation to civilized decisions regarding alleged crimes. Instead of allowing the Furies to torture Orestes, Athena demonstrates her wisdom by deciding she would have both the Furies and the Orestes plead their case before she decided on the verdict. In addition, Athena set up the ground rules for how the verdict would be decided so that everything would be dealt with fairly. By Athena creating this blueprint of precedents, the future revenge killings and the merciless hunting of the Furies would be eliminated from Greece. Athena responds by setting up a trial for Orestes in Athens on the Areopagus. This trial is made up of a group of 12 Athenian citizens and is supervised by Athena. Here, the trial of Orestes becomes the first courtroom trial known in literature. After the trial comes to an end, the votes are tied. Athena casts the deciding vote and determines that Orestes will not be killed. Athena proclaimed the innocence of Orestes, and he was set free from the Furies. This does not sit very well with the Furies, but Athena eventually persuades them to accept her decision. Athena's message in the play is that instead of violently retaliating against wrongdoers, the Furies must become a constructive force of vigilance in Athens. She then changes their names from the Furies to the Eumenides, which means the gracious ones. Athena then in the play ultimately rules all trials must henceforth be settled in court rather than being carried out personally for vengeance, for civilization demands as much from all of us. The cycle of murder and revenge had come to an end, while the foundation for future litigation had been laid. Aeschylus, through his jury trial in his literature, was able to create and maintain a social commentary about the limitations of revenge, crimes, and reiterate the importance of trials. The Oresteia as a whole stands as a representation of the evolution of justice in ancient Greece and precedents today. And finally, with technology becoming more important in the admissibility of evidence in our courtrooms, and with technology making our jurisdictions in the future even larger by including the virtual world. We're learning about the metaverse as judges in the American Bar Association by seminars. And that's going to be added to our actual world jurisdiction as we now know it. So therefore, judicial education plays an even more vital role with judges and the courts. Forensic science concepts are becoming more complex, yet more reliable, with international standards being developed that make judicial education mandatory for our judicial roles. Identifying suspects with facial recognition techniques and speaker recognition methodologies, as well as fingerprints and other forensic science techniques, make the role of judicial education in these fields beneficial and necessary to judicial education. For instance, admissibility and authentication of social media posts make our roles as judges more complex as we strive for truth and justice. Judges become the pioneers in this precedential legacy of the future as representatives of an independent judiciary upholding the rule of law, and precedence represents justice. Precedential law is to be respected and revered and should only be changed where social justice needs to change precedent. Precedential law has existed from the early times of the ancient Greeks and is not, as we have learned, is not a new concept. Precedential law is necessary for civilization and ethos to coexist with justice. We as judges must be the Athenas of our courtrooms, representing and respecting precedents and justice for all. Thank you.
Thank you, Judge Dmitrovich. Thank you so much for your presentation. And we'll just go right to the next and the last speaker, Dr. Sam Amadi.
Thank you. It's my pleasure to be part of this meeting and to say that I've listened and I'm delighted to be part of it. First, I would like to, as a lawyer, as a policy person, and also as someone who teaches jurisprudence at the university, maybe I will try and be as practical as I can. Clearly, the courts in Nigerian history has been seen as a center of political struggle. I went to the law school at the time when Nigeria was coming to the end of a military rule. And there are several actors, social actors that played key role to bring to the end of military rule in Nigeria. One of such, of course, the labor union, the students' union, the Nigerian Bar Association, which is an association of lawyers. But oftentimes the site for this struggle was also in the court. So the court has played a key role in fostering a transition to democracy. Before I go further, I'd just like to make a couple of observations about the role the court has played. In those days, I worked with Chief Gary Fayemi, which is who was one of the leading human rights lawyers in Nigeria, and now late. And he was also responsible for filing many of the tragic impact cases challenging military rule and some of the obnoxious decrees that the military enacted during that period. It was obvious for many of us who work with Chief Gary Fayemi that he saw the court as an important instrument for driving transformation. And he quoted for us one of his favorite quotes was from Nigeria's first lawyer on the road, Chief Sapara Williams, who said the lawyer lives for the direction of his society. So that was part of our experience. I know that period, Professor Isasage wrote a book about the Supreme Court, and that book chronicles clearly the activist role of the Supreme Court. So the Supreme Court of that period, of the 1980s and early 1990s, was a court that is probably likened to the Warren Court in the US during the civil rights period. A court that kind of led through jurisprudential, through the jurisprudence and their decisions that contributed or even led to empower citizens against military rule. So that particular period, which I witnessed before we enter into the democratic rule, it shows clearly what the court can do and has done in Nigerian history to facilitate and aid democratic struggle for human rights, for an accountable society. So that's well documented in decisions the court has made, and of course, thank to Professor Sage for providing a theoretical recollection and, of course, expression of the role of the Supreme Court. Now, I would like to look at this in three ways. One is to show or argue on how courts actually become agents for social change. Second, I will look at is the benefits, how important the positive side of it, and of course the negative side of it. And end briefly with where we are today in Nigeria. There are many theories about the courts. We inherited the British after colonial rule. We inherited, of course, we're a Commonwealth country, but our law, our procedural law, have been guided more by the common law tradition in the UK. But from 1979, we became a presidential democracy with the result that our constitutional law and constitutional framework, including the framework for the courts, became more aligned to the United States model of governance. And so what I created was some sense of confusion or incoherence between the Nigerian procedural law that define some of the ways in which the court functions and the constitutional law that locates the courts at the heart of contestation through judicial review. So our Supreme Court, particularly, in their decisions since 1979, have followed the US Supreme Court's initiation of the power of judicial review, the power to strike down legislations, the power to check the executives and legislature. But our procedural law and the conventions that define our judicial practice remain somewhat, embedded in the British common law tradition in which we are kind of nurtured. And so what you see in some of our decisions, especially when it comes to some constitutional decisions around freedom of religion, right to liberty of persons, especially now, in this new Supreme Court, a new Nigerian judiciary, is some neither here nor there, following through the US Supreme Court tradition, but coming short of some of the ways they have tried to balance the right of persons and society, try to balance liberty and security. So that lack of coherence is one of the things I research and write about, that we have what I call constitutional incoherence, in that our constitution primes us to resemble the US, in this US Supreme Court particularly, but at the same time, our procedural law constrains us to be like the British High Court or the House of Lords. Now, as early as in the 1960s, the Nigerian Supreme Court has been very clear on its role to hold the banner or hold the wall against military or all forms of authoritarianism. One of the landmark cases of human rights, Ransom Kuti against Age of Federation in the early 90s, in the 1960s, was also a case where the court had to declare action against the citizen as unconstitutional. And the court has built on that tradition ever since, exercising the right to protect citizens. During the military rule, we saw the court faced with some kind of problematic. The military rule they come with a decree essentially suspending some of the constitutional provisions, especially to human rights, and again predicating the essence of judicial review subordinate to their own fundamental law, such that some of the privative decrees, like decree number 2, which sought to punish persons or restrict the exercise of freedom of expression and of the press, the court had to find a jurisprudence that was restrained, respectful of the local order, but at the same time protects human rights. One of the ways the Supreme Court resolved that is to say that when the military intends to reduce or remove these rights, the court still, even though when they say the court has no jurisdiction to adjudicate on matters pertaining to these decrees, the court still has the right to ensure that actions taken pursuant to those laws were strictly in accordance with the provisions of the court. So although the court is asked not to exercise jurisdiction when, for example, the IG of police declares a person a security risk and therefore exercises the power of preventive detention, the court has to make sure that the action taken pursuant to these decrees align or are strictly in accordance with the express provisions of those. And where the actions do fall short of those provisions, the court will step in to nullify such action. So with this kind of jurisprudential maneuvering, the court tried to ensure that without being reckless and therefore violating the new legal order, they also were able to protect lives, protect liberty and freedom of citizens. And thankfully, now we don't have those kind of decrees that sought to or purport to remove the jurisdiction of the court. Of course, in IGA against Madike and several other cases, we saw that happen. Now, so essentially, borrowing from Marbury and Madison, the Nigerian Supreme Court has established the right to judicial review. But what may not have happened is that the court has not been able to clearly articulate in the same way the US Supreme Court has done in where conflict between liberty and security or liberty and stability of the state seem to conflict, the requirement of overriding public interest. The Nigerian Supreme Court has not been that explicit and articulate in crafting a judicial framework to arbitrate that. And we saw that major failing in the recent case of Asari Dokubo against IG, where a Nigerian activist, if you like, was detained, preventive detention, and the Supreme Court said that where human rights conflict with security of the nation, the court, those rights could be breached. But that case did not come to the level of sophistication that we have seen the US cases articulating the need for for such laws, for government to show overriding public interest before we can claim that security should trump rights. So bottom line is that the courts have played key roles as agent of change in the area of advancing democracy and human rights. We also see the court play key role in the area of cultural transformation, which is another aspect, not just about rights and democracy, but also changing culture, or in a way, without being muscular, but in a way, helping to change culture and custom. And we saw that clearly with regards to women's rights, some cultural settings, Southeast, where women could not, by custom, inherit, discrimination against women in inheritance. And the Nigerian Supreme Court was very emphatic to say that such customs and tradition unconscionable, violates the fundamental rights against discrimination and therefore at law. So by these decisions, the court itself, especially at the highest level, have led in some kind of guided and strategic cultural change, agents of change, without denouncing culture and custom, and therefore provoking fight back. The court have used the instrumentality of constitutional interpretation to knock down on some cultural practices that are extremely maybe dehumanizing, and one can say in that sense, not primitive, but essentially no longer aligned to our modern concept of freedom and liberty and equality. Again, recently, with regards to the Sharia, the execution of Sharia criminal code, Sharia criminal code, the Supreme Court also, through the recently retired Supreme Court Chief Justice, struck down the mode of execution. They resort to mob execution in respect of even criminal Sharia offenses, even when those offenses are real and the process for trial and the law prescribe punishment. The Supreme Court says that by virtue of the Nigerian Constitution, and even by Islamic law, there's no resort to mob justice. And so some of these laws these judgments have changed the dynamics. Now, the question I would like to focus again is, yes, we can see that our courts have been agents of transformation, whether in terms of human rights, in terms of social culture, in terms of empowering those who have been marginalized, providing them rights, and in terms of also constraining exercise of executive power through the administrative state. But the question is, how are is this all positive or negative? And what kind of negative consequence can flow from this, from an activist court that is playing a leading role in maybe changing behavior or trying to assert itself between authority and the people? First, on the positive, of course, the decisions of the Supreme Court right from the 1980s up to now, particularly in the 80s to early 1990, has been one of the corpus in which we are building Nigerian democracy. Arguably, without the leading role of the Supreme Court, maybe some of us who were in the trenches fighting military rule would not have had supportive rhetoric and bold norms in which to widen the space and put pressure on the military. So that's a positive development. On the positive side, of course, like I said, the courts have also become an agent of transformation to lead to dialectics of cultural change without necessarily pushing too hard against culture itself, but helping to revise custom and culture in a conventional sense. That's positive. The possible negative side of the activistic role of the courts using judiciary is that oftentimes the courts have also risk being mired in political controversies. And that's one of the things that weaken in the long term the epistemic authority of the courts. There have been debates in the US and elsewhere in the world as to how democratic is judicial review. Should the courts be entrusted with the responsibility to champion either social change or to be the custodian of democratic freedom against politics? The courts are essentially unelected in Nigeria, totally unelected wise men and women. In some jurisdictions in the US, maybe at some level, judges are elected, but here they are unelected. So the theory then is, should we entrust our judges to play more leading role in politics? So the normative question around whether that's compatible with a sense of democracy, especially populist democracy, where the people themselves are now, getting more muscular in redefining true democracy of norms, the conditions in which they live. And that gets back to the US Supreme Court's recent decision, throwing back to the legislature, the state legislators, the right to decide a vexed ethical question around the right to abortion. So the democratic question is, how far should the court go in leading in changing society, whether in terms of expanding rights or in terms of changing cultural practices? The other question is about the efficacy of this activism. In other words, how much does the court hurt its epistemic social capital, if you like, in becoming an activist court? Some arguments, and some people have argued, that the judicial craft does not align with the interest bargaining that is implicit in democracy. That means, whereas legislators are free to make strategic and sometimes unprincipled decisions affecting outcomes, the courts, as a rational institution, does not make interest, has no right to, does not bargain interest against interest. The court uses formalism, the court uses logic to tease out principles implicit in justice to address disputes. And so by that epistemic or pedagogical or epistemology, basically, makes it difficult, or rather makes it unwise for the court to thrust forth into societal contestation over values and how people ought to live. So in other words, even if the court can do that, the court weakens its power ultimately to deal with real case or controversy if it becomes politicized by virtue of its activism. And so that's one example of that we can see in the US now is some dispute as to whether we should even have the courts themselves, the Supreme Courts, whether we should elect them, whether we should tenure them and limit their tenure, because people feel that they have become part of the commonwealth of contending and incommensurable value struggle, the fight over values and outcomes, so that the court itself, by becoming part of that conflict, has now removed from itself the shield, the judicial halo. And so for a country like Nigeria, whereas we want the court to be, maybe to remain agent of social transformation, we should worry that the courts themselves do not, by so doing, harm their authority, do not expose themselves so much that they will lack the authority to enforce or make decisions that were binding, especially in the context that of all the three branches of government, the court is the only one that lacks, that doesn't have the executing power, the authority, the army or whatever to enforce. So the court rights on the normative bargain that the people accept that these judges are people who want to entrust with decision to decide cases and controversies. And so because they are powerful, they don't have the force, the coercion against society. And so there's an implicit trust that whatever they're doing flows from rational, non-discretionary application of principles already implicit in law. We know that this positivist notion has been knocked down by the realists and the critical legal studies, but essentially, it remains at the bedrock of the judicial craft. And so the question is, if judges thrust far into the ocean of incommensurability, contestations, and drive this transformation, which is going to be ultimately ideological one way or another, the court might get hit back by dissent and rejection by people. And since the court has no power of coercion, then it might be in a difficult position, and ultimately it might not work good for it. So to round off on this point, I would like to bring in the decision by the industrial court mandating that the judges of the Supreme Court should be paid 10 million, 9 million. I mean, most Nigerians feel that the sentiment behind that decision is unimpeachable. The judges are not well remunerated, and we need the judges to be well remunerated, not just in naira time, but in providing for them all the supporting system for efficient and fair justice delivery. But again, the question is, this should be what should be done. It's an administrative, not a judicial action. And so by nature, if a judge fixes those mandates that judges should pay 10 million, 9 million, it risk getting blowback from the society. So basically, that decision for me provokes the question, how should judges consider their craft and their interventions? They sometimes can be provoked, like Professor Dell of the UK political scientist argued. He says, look, that the court is a political institution. Today, say that the court has resources, expectation, and functions in the political environment. The court therefore has political responsibility. But the question is, that responsibility means that the court should be part of the debate and discussions and part of pushing for justice, humanity, and freedom. But again, the court is a unique political institution, and therefore the court should be restrained, careful that its intervention in the body politics does not wear the toga of politics or does not become, like the legislator, an expression of its own interest or will, but rather, as we have always believed, as a rational application of principles that are in themselves implicit. And so where society is caught in massive or unending disagreement over several issues, most of them ideological, the court risks being trapped in that ideological warfare. And if it gets trapped in that ideological warfare in the quest of being an agent of social change, the court might lose its epistemic and judicial authority. I think I would like to end on that note to say Nigerian courts have done very well in being agent of change, but also it has been episodic. We've seen that mostly under the military rule, and we are seeing that less under democracy. And the explanation it could be that under military rule, the court becomes the last agent of change. But under a democracy, the people themselves, through their representatives, become the agents for change. And the court steps back, pulls back, and basically sits there to apply their wisdom to cases and controversies that are defined and between individuals. Thank you very much.
Thank you. Thank you so much, Dr. Amadi. Thank you. We appreciate everybody who has taken the time so far to be with us. That is all of the presentations, you will agree with me, have spoken to the topic extensively from different perspectives. I would summarize briefly, as I've indicated in the chat box, that we have special and distinguished personalities that are joining us from the NJI. They're actually having a workshop going on at the moment, and it's a room full of about 30 persons that are joining us from the NJI. And we'll be talking about the position paper shortly, but I would quickly summarize the speakers as we have had them. We had celebrating Sierra Leone's judicial jurisprudence, Justice Alison Sosay, and Justice Sosay spoke about how the judiciary of Sierra Leone has impacted social change in diverse respects, about the Citizenship Amendment Act and how it has affected sexual offenses and related offenses, particularly as relates to sexual offenses against young girls below the age of 18. He talked about, most interestingly, I found, he talked about judicial activism, where he spearheaded and established, and went on to discharge over 300 inmates. And interestingly, which is what this Courts and Society webinar is all about, as we would agree, he said that those inmates have been incorporated into society and are very much part of societal development. So it's not just about change, it's also about implementing the change and ensuring the impact, ensuring that that change impacts the society, as Justice Sosay has given us, that those inmates, I'm sure, of course, that the Sierra Leone judiciary or the prison system or the justice system is keeping a data of these prisoners, that they have been incorporated into society and are making societal development. So which is a fundamental aspect of courts being agents of social change. And he did say fundamentally it's an interactive session, which is what this is all about and why we're going into questions, and we'll give enough time for questions and comments. And so we are bringing all of our experiences, all of our expertise from different walks of life and our cultures, judicial cultures, legal cultures, to talk about what is most important. Then we've had Dr. Makoba come in to do his presentation from another perspective, a sociological perspective, where he said that the society is actually the agent of social change. From what we see that the Milord Justice Sosay had talked about change from the court's perspective, Dr. Makoba is saying, indeed, from Roe versus Wade, you can see that the American society had a great deal to play in changing jurisprudence. So he has said that it's important that society is very much involved and society be part of that role for social change. He did mention a few cases about in South Africa, about how the courts did impact social change, and a case in Kenya, and also referred to his hometown, home country, Uganda. And then we had Professor Utome, which brought also another very interesting perspective that I didn't see coming. He commended the judiciary and agreed with everyone about the fact that the judges and courts are agents of social change. But he has also pushed it out there and said, we think that the lawyers could do more. We think that the NBA can, equity says you can't put something on nothing and expect it to stand. If the lawyers don't take the matters to court, and if, like he referred to the late Chief Gani Fahimi, may so rest in peace, if he had not taken some cases in court, there wouldn't be jurisprudence today, there wouldn't be change in certain respects. So he has encouraged that the lawyers, as he often, relates with them, giving them presentations in NBA conferences and presentations in NBA meetings, that the lawyers would be good agents of social change. And he has also said that there can also not be social change, maybe a little agreeing with Dr. Makoba there, without civil society organizations. That, and it's true, civil society organizations, particularly I know Social and Economic Action Rights Center, CERAC, that I was working in, had to do a lot with change in the Niger Delta area with respect to oil abuse, use of oil exploration as it respects to abuse of human rights. And then we had Honorable Dr. Domitrovich, who took us to an interesting aspect, which would be a very convenient introduction of our National Judicial Institute's short program that we're having shortly. She talks about the importance of judicial education in societal change, that when the judge is educated, when the judge is enlightened, when the judge understands that the perspective from a judicial angle, from an educated angle about society and all of that, the judge is better able to adjudicate in line with social context. And then we end in with Dr. Amadi, who has cited several cases and talked about the role of courts in cultural transformation, where he has said that the courts have led and guided strategic cultural changes in Nigeria. And interestingly, he did say that it wasn't, with the word he said, not with muscle, that the courts kind of, I would, for lack of a better word, use empathy, that the court, as part of society, has changed some cultural practices that has not necessarily affected the foundation of culture in that specific region. And that is something very interesting for judges and courts, because as I argued in my dissertation, the judge is going through a lot, as he also, and I think Professor Utome said, I empathize with judges because there's a lot. I talked about the dilemma of the judiciary, the dilemma of the judge in respect to social change. And Dr. Amadi also talked about referring to the Chief Justice, the former Chief Justice's stand on striking out mob execution, which, like I said, if for those of you who attended earlier, that it was part of what started the inquisitive mindset of a young lady, a child actually, 8-year-old, who saw a mob in Gidadambe in Maiduguri, where my mother had a store, and this middle-aged woman was being stoned to death, and her crime was adultery. So in my young mind, I saw that, and I felt really hurt by the fact that I felt judges were not being reasonable and considerate. That why would justice be to kill somebody because she had committed adultery? What happened to the man? And stuff like that. So all of that would take us now to questions and answers. If you have any questions, you would please feel free to put them in the chat box. And after the questions and answers, we would have responses from the various presenters, those who are around, as we know that Professor Tome is not with us because he's in transit, as some of you who noticed he was at the airport when he was talking, and we then would have responses. But for now, we'll be going into a session. I explained earlier for those who tuned in earlier that the Nigerian Judicial Institute is having a program, a workshop on curriculum development. I don't know if the head of the committee would want to say a word or two before I start. If I had called on Honorable Justice Kenneth Amadi, Justice of the Court of Appeal, Nigeria, my Lord, if you would say a word or two before I commence. Or with your leave, I can go on. So A.T.Socio-Judicial Consulting is consulting for NJI on developing a course or developing courses for the curriculum committee under our Research on Judicial Education platform. Our mission is to create courses that will advance judicial education and empower judges with adequate knowledge of social context awareness and the social judicial impact of judicial decisions on societal change and development. I'll be giving a synopsis of my 5-paged position paper for obvious reasons. This is a public platform. We have not had any, we've not made it public yet, so we want to guide our intellectual property and copyright. How courts impact social change. So because, and we tried to merge part of the workshop and the webinar because it's talking about the same thing on social context. So I tagged this aspect of the program, how courts impact social change through judicial education. And we recall that Justice Judge Stephanie Demetrovich did mention the importance of judicial education. And she said that judicial education is priceless, and we encourage other judges to receive judicial education. She analogized that with the ancient Greek historical perspective and encourages that judges should encourage one another to come together and be educated in various respects. So before I go on, I'd like to give an ovation and accolade, acknowledgement and recognition to all judges, justices that are present here and their colleagues that are not. Precisely and particularly the judiciary, the great judiciary of Nigeria that has gone through thorns and turns and through military regimes and has stood firm. A lot of people would say the Nigerian judiciary is corrupt, the Nigerian judiciary is a problem of the country, but any judiciary who has gone through the pains and the hurts that the Nigerian judiciary has gone through with little or no acknowledgement and recognition would not do as much and as great as the Nigerian judiciary is doing. So I give an ovation to the Nigerian judiciary, to the judges, the CJ Chief Justice, the justices of the Supreme Court, the justices of the Court of Appeal, the judges of various high courts, and all the way to the magistrates, the grand qadis, and Sharia courts. Thank you all for what you do. It is not an easy job. It's very taxing with a lot of dilemma. A.T.Socio-Judicial's consulting paper to Nigeria's National Judicial Institute Curriculum Committee. The course that I propose, that A.T.Socio-Judicial Consulting proposes, is the Nigerian Judicial Practice, and it is NJP 1 and 2. The part 1 would be for new and aspiring judges, and the part 2 would be for the old. Of course, the new and aspiring judges would eventually take like the law school bar part 1 and bar part 2 exams, would eventually take the NJP 2 course. Now, the course overview. And based on over 19 years of research on courts and society, and my personal experience from CERAC, those of you who came earlier, and I talked about the history of courts and society webinar, from when I was in the non-governmental organization CERAC, and I related with community and attended pro bono litigation for them in magistrate courts, to courts of appeal. And then my personal experience for over 12 years in the magistracy of Lagos State, sitting at Igboshere, Tinubu, and Adino-Ogusoya magisterial districts, very busy and complex and challenging districts with very smart lawyers, smart in the sense of the word and smart with inverted quotations, smart lawyers. And then informal interviews of judges. In my dissertation of 12 chapters, I had informal interviews of judges from retired justices, then to sitting Supreme Court justices and Court of Appeal justices, then High Court, Federal High Court, Industrial High Court, and then the magistracy. And of course, JSC, some retired magistrates as well. With that, I found, and it's consensus from all my interviewees and persons that I interviewed, that the public and even some judges undermine the roles that courts play in society and social change. Because like a conversation went on with one of the judges, my informants, he said, if we don't impact social change, then what are we there for? Judges impact social change in diverse respects. And part of what the course is proposing is to get Nigerian judges and eventually judges in Africa, as the National Judicial Institute is an institute that is making impacts in Africa and eventually will across the globe on judicial jurisprudence in Africa. Now, getting judges to attend these courses, take these courses, and train in these courses would expose them to not just what they are going through, but what others are going through, and understand that they are not alone. The job of the judge, like the late, irrepressible, unforgettable Nikki Toby would say, is a lonely one. It's a lonely walk, and human beings are not created to be lonely. It's important that we try to empathize with our judges and encourage our judges, which is what the NJI is set out to do by the call for papers and position papers for memorandum. The NJI is more, I would say, not just a school, but a clinic for our judges, trying so hard to see how they can be of help to the Nigerian judge. So this course would explain the role of courts, these courses, I beg your pardon, would explain the role of courts in society and democratic development. As we know, one of our speakers, I think it was Dr. Amadi, that said the role of the courts in democratic development. And I think Professor Otome actually also said as well, the importance of courts in democratic development. It is very important. So that basically the objective of this course is what, as judges, what role do we play? And I said in one of my presentations, a presentation I had at University of London 2 weeks ago on the role of courts in social change. And in that presentation, I said, if judges are not agents of social change, then it's like we're putting putting a database of cases into a computer and telling the computer to just reproduce everything we're giving back. Not directly challenging, and I speak from two sides of my mouth, not directly challenging precedents, but somehow challenging precedents. Because we come to a place where we have to, like the National Industrial Court of Nigeria, I salute the jurisprudence in that court and the tenacity and the zeal and courage in the judges of the National Industrial Court of Nigeria, to take precedents as it is, analyze it, dissect it, and put it at pair with society and see how the context makes sense to the interest of justice and democracy. So the courses that I suggested are seminar-like pragmatic courses that will further highlight contemporary social issues. We go to different judicial trainings. A lot of us have been having trainings in different parts of the world. We go for seminars, for conferences, and a lot of them, Commonwealth Magistrates Judges Association Conference, wonderful presentations on judges and everything. It's also important that judges are taken to a classroom outside the classroom. Like in the Mind's Eye, it's like a laboratory. In one of my chapters, I did analogize or compare decision-making to being in a lab, where the court would dissect facts, principles, laws, status quo, precedents, and come about a decision. In that place, I was talking about the dilemma of the judge, which is also part of the comments that one of our presenters made about judges going through dilemma in social change because the human being is diverse and complex. So the contemporary issues, what I'm expecting is, for instance, and it will be very discrete classes in terms of judges would be encouraged to turn off their phones, because it will be classes that would involve talking about cases that you have decided on in the past. Of course, you can't talk about pending issues, but where is the law or the ethics, and I would push for that, the ethical or code would allow that a judge can talk to a fellow judge about a pending case in terms of getting enlightened and all of that. It would be part of such seminar-like classes. So two of the major course categories that I suggested would be from an historical context and a contemporary context. Like I said, for obvious reasons, I'm not going into details of the paper, but for the NGI committee, my Lord Justice Amadi, I take your leave to please not go into details of my presentation, my paper before you. So I'm on page 3 now. I plead on my webinar attendees to please forgive my being careful with my intellectual property. Many Nigerian judges have faced these issues. So historical context would help a judge. For instance, I heard recently, with all due respect, a set of appointments. Oh, this person is not qualified to be a judge. The person is not even, interested. The person is not even up to base with the law. So why is this? Now, these people, right, who eventually several people are complaining about, do not qualify to be a judge because, and I feel really sorry and empathize with and I'm going to be a bit biased here, with my judicial brothers and sisters, offsprings of judges and justices who get into the job on the merit, but they say, oh, now because now this person became, is this person's child. That's why she or he became a judge and stuff like that, and I pray that you prove them wrong by your work and your output in the judiciary. Now, so this historical context would help such judges who maybe quote unquote truth or no truth are coming into the judiciary with a mindset of, let me just get a job, a safe job. Now, when they attend these courses, they would have historical perspective, historical context, and believe it or not, it has a way, when you're in a room with other people of like minds, or a professor or a teacher who has the passion to teach, you would have that synergy, and it would tell on, and eventually as you adjudicate, you would have that mindset of, I'm not here to play, I am here to change. I remember in one of my first promotion interview from magistrate, to SM1, senior magistrate 1. And they asked all of us the role that we play. We looked at ourselves and everybody started asking, well, what do we do? What do we do? What's our function? We all, and everybody had different answers on what they do. And so historical context is very important, and that will now eventually take us to issues of philosophy, and it would also make judges to think about philosophy, because judicial philosophy is very important, and that is an historical jurisprudential perspective. Then we go to course 2. Course 2 will be talking about specifically what those roles are. After we come from a historical perspective, we're now going to introduction. What is it we do? Because if we don't identify what we do as judges, some of us would go into the career or would continue being discouraged, being distracted, and not being impactful to society. And again, I quote my mentor saying, what use is the court to society if we're not impactful to society? So these courses, these categories of courses, the historical context and the contemporary context, have been broken down into 10. And the first one talks about democracy and how the court unfolds its role in democracy, as we heard Dr. Amadi say and Professor Tome say. Then the judge in changing society, that's number 2. And remember, just Dr. Makoba talked about the role of society in the Roe versus Wade status quo that has now taken a new turn. And then, most importantly, judges go through a lot. Some of them die on the job. Some of them die after the job, not having time to enjoy their post-judicial life. So it is important to talk about judicial health and traumas that judges face when they go through the process. So yes, once in a while, Nigeria judiciary and many other judiciaries are doing excellently well in taking judges out of the country to go on presentations and all of that, and retreats and come back. But that is not enough. Prepare the judge for retirement. Prepare the judge for eventual issues that would come up. Let judges meet and interact, which is what A.T.Socio-Judicial Consulting is hoping to do with our judicial education platform, to introduce us to cultures. And we heard Justice say expertise from different countries with experiences come together. That is the whole aim of ATSJC. We want all judges, professors, society members come together and let us share our experiences, and to be able to say, this is what I go through. One of the things we did when I was in Reno, Nevada, I remember the Canadian judge from Canada, and we, after our evening classes, we actually broke the law. We were jaywalking. Jaywalking, for some of us who don't know, it's crossing the traffic light when it's red, right? And we all started laughing at ourselves and saying, so look at you judges. If they bring someone to your court now to say the person crossed the traffic light, what would be your verdict? And we laughed at ourselves. But for the first time I'd never, other than my late father, I had never judges so relaxed, so relaxed and very themselves and still in control of their ethics, but some are letting go and losing up and all of that. So those are issues that we need to take very seriously. The life of a judge is a lonely one, and it can kill. Incidentally, like I said again, my late father did say that, and unfortunately, be careful what you say. He did die of a brain tumor because he worked himself so hard. He said, and that is in my language. It says, this job is a job that kills. So the job of a judge is one that needs serious empathy. And I'm hoping that together with NJI and many other institutions that I'm hoping to collaborate with, and with Judge Stephanie Dometrovich being with me on this, to help to look for funding for the Nigerian judge and eventually African judges through the platform of Judicial Institute, the National Judicial Institute, to talk about judicial traumas and how it affects the judge, and making ways to help the judge, the African judge especially. That will be the end of my presentation. Thank you. Do we have any questions, please?
Hello?
Yes, does anybody have any questions?
Okay, so we have one comment and one question.
Thank you.
Can I go on with the comment? Or
Yes, please.
okay, so there's no doubt that courts are agents of social change, but some decisions of courts could also be antithesis to positive change by creating a chaotic environment. For instance, the recent decision of the Supreme Court legalizing the wearing of hijab in a secular institution could be a recipe for chaos rather than social cohesion. Can any of the presenters comment on this, please? That's the first one.
Would any of the presenters like to take this question? Do you want the question again? Would any of the presenters like to take the question, please?
Okay, let me go again. There's no doubt that courts are agents of social change, but some decisions of the courts could also be antithesis to positive change by creating a chaotic environment. For instance, the recent decision of the Supreme Court legalizing the wearing of hijab in a secular institution could be a recipe for chaos rather than social cohesion. Can any of the presenters comment on this, please?
We haven't had the benefit of reading the Supreme Court case, so I don't know. I cannot comment. It now has precedential value, and I don't think I should be criticizing as a judge another court. I assume it's the Supreme Court of another jurisdiction. It's not the United States, right?
Yes.
Okay. So whatever that decision is, we must give respect for. Obviously, it is one of social change, acceptance in the secular institution of the freedom to wear what is important to that person without the fear of any retaliation. And so I don't understand the comment that it creates chaos, for it creates freedom. And it is precedent in the court of the country that it comes from.
Thank you.
Like my sister, Justice Stephanie, has just commented, it's not for us to criticize the decision of any other judge. But if you can recall vividly, when I was presenting, I was making my presentation, there is a phrase which was very clear, and I placed much emphasis on that phrase, the issue of positive change, that this is a positive social change. If the decision of the court goes that way, it becomes chaotic, then the court has not in any way served as an agent for positive social change. But if it is something that society will eventually emulate, it will transform probably the behavioral pattern of the society. Then the court has now performed its role as an agent of positive social change.
Thank you, sir.
Yes.
Anyone wants to comment, add more? Anybody else wants to say something? Very well. I would like to quote a friend who said, "You cannot create change without making enemies. Change is about making enemies." So a lot of times, courts would bring about a decision that would not be favorable to. I don't think judges or courts can please everybody, which is one of the issues I had in mind when I wrote my dissertation and said, courts, the dilemma of the judge. So it's important for us to know that judges go through that dilemma of for or against, how does it fit into society? There are so many things going on. They have the interest of society. They have the interest of the individual, the plaintiff or the defendant, or they have the, depends if it's a civil or criminal case, they have the interest of the state or the interest of the prosecutor, they have the interest of the courts, the judiciary, they have the ethical interest. Now that is one thread that holds the judge at the back of his neck every time the judge moves. Everything else but the ethics has a way of, you hold your brakes. Okay, is this against the code of conduct of the judicial officer? Would this get me in trouble or not? And which is, why I really commend the Sierra Leone judiciary in taking that outright judicial activism. So it's a dilemma for the judge. There is no way that a judge will not make a decision that will not affect society in one way or the other. In the same way you talk about the hijab, let's talk about the Roe versus Wade. Now, when the decision was leaked, or I would rephrase, when they said it was leaked, people went and wanted to go to houses of judges. We're looking for houses of judges to go and talk about this. So there is no way, and there's a divide. And if you look at it, the red states versus the blue states in the United States, and red, Democratic and Republican, we have a certain side that is more. So you would think that the Roe versus Wade would be sustained because we have them more, right? So you never know with society what would be against them. There is no judicial decision that would always be 100% lovey-dovey. The judge, like Lake Nikitobi said, the Nigerian judge in the book, The Nigerian Judge, he said, the judge would always be the enemy of society. One person loves him and the other person hates him. You can never go please society. So whether it is a hijab today or a Dibia outfit tomorrow or a priest outfit tomorrow, there will always be something that the judge would have to face a dilemma of how to decide. And that is unfortunately the cross that the judges have to bear. So be a little more empathic towards judges because they do a lot. Next question, please.
Okay, so the social engineering and pushing the frontiers of civilization brought about by decisions of courts could not have been possible without citizens spurring the judiciary to action. The instances where the courts are underfunded and the personnel of the courts, both at the bench and administrative arms of the courts, are made to work within onerous conditions. The poor condition of service is likely to affect the quality of decisions of courts. The court employees and judges of lower courts, usually the closest to the citizens, are worst hit in the scourge of lack of funds. This situation erodes the confidence of citizens in the courts and would rather seek redress of grievances through self-help, usually using the police to inflict vengeance on the persons with whom they have disputes. How can citizens' confidence be restored in the justice system? And what is the best way to fund the courts?
Thank you.
In the United States, we believe in the independence of the judiciary, as I'm sure many other countries do too. The courts should be funded separately. Unfortunately, in the United States, that's not always true. They must go to Congress to placate them, to get the money to fund the judges' education and their employees, etc. So if we lived in a perfect world, maybe in the metaverse someday, which is out there as a possibility someday, we would have that type of funding to help everyone and to give them the proper wages they deserve as judicial employees and court personnel. Unfortunately, the reality is that even in the United States, they are underpaid, they are criticized, court personnel. It's unfortunate, but I believe that hopefully things will change and evolve, and that precedent can be obtained to allow for a unified court system that is funded for the courts to properly distribute justice.
Thank you.
Yes, can I say something on
yes,
that?
Peter.
Yes. Yes, in addition to what my lady Justice Stephanie has just responded to the question, I attended a seminar once and a judge was arguing. He was arguing very, very, very seriously in saying that independence of the judiciary requires financial independence. And he said independence takes different connotation. But I will also re-emphasize here that judicial independence requires funding, sufficient funding. And funding does not only entail remuneration of judges, it also entails the working environment. There are several other species that constitute funding, not just financial funding in respect of salaries. And it is a bedrock of any independent judicial system, because as you rightly said, that will prevent any form of lack of confidence in the judicial system. It will help to enhance effective judicial administration of justice.
Thank you, my Lord. Thank you so much.
Bravo. Bravo, Justice. Bravo.
Thank you. Thank you. Indeed. Okay, so anybody else wants to contribute or make a comment on that? The NJI is having their session now. They're continuing with their session. So maybe they won't be part of the rest of our deliberations.
Okay, we have one more comment.
Yes.
Do you want me to go ahead? Okay, well-researched, Ngozi Agubalu, well-researched and articulated presentation, but a huge hindrance to driving outcome of rich seminars such as this in Nigeria, as related to the contemporary context, is in the implementation by the executives, legislature, and even the expectations of the democratic citizenry. It's just a comment.
It is a comment, and very, very fundamental comment indeed.
Yes.
Anybody wants to respond to this? Dr. Makoba? Dr. Makoba, are you still there? Okay, any of the other presenters can please respond to the comment, which I think has a bit of a question in it. The dilemma of having to implement, yes. The dilemma of implementing. Well, something I always say, and one of the things I say on issues of institutional racism as alleged and all of that, is that once you have change in your hands, you take change into your own hands. In terms of, we wait for the government, we wait for the system, bureaucracy and all of that. It can take a while, it can take processes. So what is immediate here and now solution? First question is, how can we build public confidence in our court systems, which is one of the objectives and mottos or vision of A.T.Socio-Judicial Consulting? How is the court now seen as a mediator between law and society, between the government and society and the law, and between both parties and litigants that come before the court? Yes, you've mentioned something about money, and that is fundamental, as Justice Sosei has said. While we are waiting for the finances and the funding and the independence of the judiciary, the here and now, what can be done? The judges can take their own change into their hands by starting one day at a time. In your little courtroom as an area court judge, customary court judge, magistrate court or your elaborate courtroom as an appellate court judge, or judges of the Supreme Court, or a judge of the World Court. Wherever you find yourself in that panel of election tribunal, family court, wherever you find yourself, what do you understand as your role? Because when a person identifies his purpose, relevance is inevitable. When people can see that you stand for what you are designed for, appointed for, created for, inadvertently, without knowing it, you are making impact. So as a judge, when you go to the court, what is the most important thing for you? Is it to be seen, to be heard by people, or to write impactful rulings and judgments that will change the system? And in your role, are you being, like I said, the roles of judges has changed. We are now moving from ordinary role of, no, I beg your pardon, not ordinary role, of historical role and status quo role of interpreting and settling disputes, to one of being an intermediary, to one of being manager, sort of, and a supervisor. So it's important that the role of judges, even with the COVID, has changed or has been added or transformed. So it's important that while we wait, as we believe that funding is fundamental, let us as judges, individual judges, talk to ourselves. What is my role? What do you understand as your role? And hopefully there will be enough resources for the NJI to incorporate some of these courses or all of these courses that would sit together and understand what the roles are, and eventually maybe impact policy change where roles of judges are stated and outlined. I remember during my dissertation, I researched, and I did not come across one law that defined what courts do. So it's important to understand that what you are created for, if the purpose for who you are created for is not understood by society, then there's a problem. What is justice for the courts may not be justice for the public. So that is also a breach of gap there. So if the public does not understand the justice you are preaching, the justice you are writing, the justice you are saying, then to them, they don't have justice. Also, they don't trust you. Like one of my mentors did say, he said, if courts, public trusted courts, they won't go and burn down the Goshere High Court. So sometimes it's not about the money as much as it is about the integrity of the personality. And when I say personality, I mean judicial personality of the judge or the court in question. Thank you. Does anybody have a comment? Anybody else wants to say something? Okay, so I would give to our presenters to make their last minute contributions or comments. Some of our presenters had another meeting they had to go to, they had to log off for that. So we have just 2 or 3 presenters. If my Lord Justice Osei would please say your final and last minute comments.
My final comment is that we have to continue. We should not relent. We have to continue to play the role as judges or the courts that we ought to play. We as judges are part of society. We should resolve to ensure that we create positive change in society that will stand the test of time, even if our generation is gone. And I thank you on that note.
Thank you so much, sir. Appreciate it, sir. Yeah. Thank you so much. Thank you for taking the time. Judge Demetrovich, please.
I agree with our justice. And I agree too that as judges, we cannot live in an ivory tower as judges. We must be part of the positive change that's necessary if the precedent must be abandoned in order to seek justice. So we cannot be isolated from the people we serve. We live in an age today of artificial intelligence and technology. One that Judge Ari Toby had talked about, had talked about in regard to computers taking over our jobs. Of course, computers cannot take over our jobs. We as judges evoke empathy when we deal with the people that we serve before us in order to teach them lessons under the law, but we also have to be students of the law. So knowing what judicial education means to other judges across the globe is very important, and it is priceless. To keep judges in the dark, to put them in an ivory tower away from the people, and then expect good decisions is ridiculous. We have to have good education available for judges. If that means that we research for grants and funding across the globe to bring in the best of the judges, the best of the experts in forensic science, to teach our judges wherever we are about the importance of technology, artificial intelligence, etc. Artificial intelligence is coming into our courtrooms. We will see them as experts. They were actually talked to judges about forensic science components, etc. But they will not replace us as judges. And as judges, we need the priceless education that's necessary, and we must seek the available funding that maybe is available through the United States Agency for International Development, whatever, but it is important for us to seek that necessary funding. Thank you.
Thank you so much. Thank you so much, Judge. That is indeed true. Nothing can replace flesh and blood. That is the value and essence of social change. Thank you so much. We have a comment here saying, Judge Domitrovich, your use of words and sound counsel is exceptional. Your presentation was worth listening to. Thank you. I have Judge Jose. We appreciate you. Thank you, sir. We appreciate your brilliant presentation, Judge Jose. Thank you for the comments so far that has been given. As we're about to round up, I don't know if we can please send emails to these questions. Like I said, for some technical reason, I don't have the questions, but I just want to take an informal poll on one or two questions that I think fundamental. So if you would please send your responses to the following questions, just 5 of them actually. The first one is, Ugo, do you have the questions with you? I'm trying to get it out.
Okay, one of the questions, one of them is, what's your opinion of the courts in your society?
Yes.
And then,
do you have?
can I go ahead?
Yes, go ahead.
Do you have confidence? Do you have confidence in your courts? And then another one is, has this webinar helped your opinion of the court system or of the courts in your society?
And yes, and then another one is, do you believe courts are agents of social change?
Yes, that's true.
So if you have, well, we would still be on till 11:30 because that is when we're supposed to end the webinar. And I'm glad that all of the speakers kept to reasonable time and their presentations were apt, very, very apt, intelligent, well-researched, and straight to the point. That gave a lot of details. And I'm hoping that we would eventually publish this Courts and Society webinar series. So stay tuned for that. And if you have to cite any of the comments here, you would do well to cite them appropriately, please. Thank you very much. So for those of you who are attending for the first time, please visit our webpage and send us an email on feedbacks, hoping that you would give your feedback after the program. So like we had said earlier, A.T.Socio-Judicial Consulting is a research platform, and through our unique concept of tenacious research about socio-judicial developments, we try to encourage people in our immediate communities and contemporary world to make attempts and research on defining the role of courts that is ever changing, and to define what justice means to society, while explaining to the public the methods and modus operandi of the judicial process, which some of them don't understand and blame us for, with emphasis on various challenges that judges encounter in executing their roles in democratic societies. And our mantra is to build and rebuild public confidence in courts. So thank you for attending. I want to specifically thank my Lord Justice Alison Sosay of the Supreme Court of Sierra Leone for taking the time in spite of the weather issues and all of that. I apologize that we couldn't put on your slide, but I'm sure that your paper would be very, very informative when it is published, as we hope that and believe that it will be ready as soon as possible. Thank you so much, sir. I appreciate all that you have done and taking the time to be with us till the end and commenting on the questions and all of that. And specifically, thank you for that judicial activism that went out there for the society and the prisoners that were let go, free men who have gone back to impact their societies. And I want to thank Judge, I beg your pardon, Judge Professor in absentia. He's probably on the flight now to his next meeting. Professor Patutome for taking the time out at the airport to attend the meeting and do his presentation from the airport, walking around and looking for where the internet would be most available. I do not know how to thank you, sir. Thank you so much for your impactful, out of the several brains in your head, you had brought them all together and made your comments of heart. That is very, very noteworthy, and the aspect of challenging the NBA was very, very impactful. Thank you so much for that. And I thank Dr. Makoba, Dr. Johnson Makoba, for his particularly insightful reference to community, which is something that I did not see initially as being instrumental as agents of social change in that respect. I thank Judge Stephanie Dometrovich. Thank you for staying from the beginning to the end. Your comments and particular emphasis on the importance and impact of judicial education, which incidentally is our next webinar topic. The next webinar topic would be the impact of judicial education on developing law and society. And our keynote speaker would be Dr. Sean Marsh, the Director of Judicial Studies Program at the University of Nevada, Reno. And the reason why he is our keynote speaker is because the University of Nevada, Reno has the most comprehensive program of judicial studies globally. And they pride themselves as the Harvard of judicial studies, the only judicial college which actually collaborates with the National Judicial College of the United States, which is in Reno, Nevada, the only judicial studies program that has extensive program all the way to doctoral in judicial studies. So he would be giving a keynote presentation, and then the discussants would be our own, like Milord Justice Ebiowitobi called him, our own school, judicial studies school principal, our own provost, our own vice chancellor in different respects and level. Honorable Justice Salisu Garba Abdullahi, administrator of National Judicial Institute, would be a key discussant, and would have Joyce Linger, provost of the National Judicial College, also giving her discussion and contributions on the impact of judicial education on developing law and society. And we would have testimonies from student judges who are presently taking the program, and student judges who have taken the program in the past, and how this program, judicial education, has impacted their decision-making in courts, as Justice Dovetrovich has so clearly articulated and emphasized over and over again. And if we're hoping to get one or two justices of the Supreme Court to tell us how, from their levels, especially judges that have come all the way from the magistrate court and climbed through different levels all the way to the Supreme Court, on how they see judicial education playing a role at every level of court. I'm hoping I can get that. Otherwise, these are the speakers that we will be seeing on Thursday, September 1st, 2022. Thank you all for attending, and God bless you.
Thank you. Wonderful job.
Thank you. Thank you. Have a lovely evening. Have a lovely day. Have a good night for those of you in Africa. Thank you so much. For those of you in Africa who will be going to bed shortly. Thank you, sir. Appreciate it so much.
Thank you so much.
Thank you. Thank you.
Thank you so much.
Thank you, sir. Thank you, ma'am. Appreciate it. Thank you. Since I don't know who particularly is here or not, I want to thank again Justices of the Supreme Court that logged in. I want to thank again the Justices of the Court of Appeal from different regions, judges of the High Courts, Chief Judges. I want to thank professors, distinguished professors. I want to thank learned SANs, Senior Advocates of Nigeria that have attended. I want to thank different professors and I think I particularly see a friend of mine, Professor Shannon, political science professor from the State University of New York on Nyonta. Thank you. I want to thank those who are still here. Thank you, Ngozi Ogubalu. Thank you, Mr. Bayo Akilade. Thank you. Thank you so much.
Thank you so much.
Thank you, Dr. Chizo DB. Thank you. Dr. Kasimu, thank you so much. Thank you so much for joining, sir. Thank you. Thank you. Thank you so much for those of you. Some of you, I can't see your names. Just, I have Mohammed Kabir Abubakar. Thank you. Since I don't have your titles, you forgive me if I call it out of. Thank you. Thank you, Dr. Mrs. Shodiko. Thank you. Thank you. Thank you, my brother. I haven't seen you in a while. Mr. Ivory, Tom Ivory, thank you so much. Thank you so much. Thank you.
Hello.
Thank you so much, sir.
I was at the first seminar too.
I didn't know that, sir. I beg your pardon.
I am following up with you.
Thank you, sir.
Well done. The Lord continue to give you grace in this work.
Thank you, sir. Amen. Thank you. Thank you, Your Honors, magistrates from Cross River, Your Honor, magistrates from Lagos State, magistrates Ogri, magistrates Kike Lomo Ayeye, our Firebrand magistrates, our Luther magistrate. Thank you so much, everyone. Students, I thank you. I see a couple of students. I see. I don't know this organization, but thank you. And for the organizations that are here, we appreciate you. Exactly 11:30 and we end our webinar. Hope to see you in September by God's grace. God bless.